Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. We are now into the spring, fully into the spring of 2023, and I'll tell you guys, it's been a bit, and I apologize. I'll tell you, if I were you, and this were like a Netflix or a cable television subscription, then I'd cancel. I wouldn't even hang around. I wouldn't keep paying my dollars for my subscription to Legal Bites because I'm simply not consistent enough to satisfy the hungry Colorado Realtors' minds for information. I'm just not doing it enough. And we had some issues with the studio. We had some technology issues, and we've ironed those out, and so I lost a little bit of time there. My agent was negotiating my new contract with the association, and a lot of work to be done there, obviously. They did say I could be a little bit less formal now in my Legal Bites presentation, so that was a win on the contract. I got no more money, unfortunately, but it is what it is. I am back now, though, to continue the series, the Commission Position Statement series on the Legal Bites Commission Position Statement series, and we're working through these one by one. We've done 1 through 6, and we're on number 7, and 7's a juicy one. Seven's a pretty good one. It comes up an awful lot on the legal hotline, and I've done a lot of education over the years on this, but I'll now have a reference point, and I can stop talking. I can just say, yeah, you got a question about moving your listing agreement, or when you move brokerage firms, what happens? Read Commission Position Statement 7, and you don't have to listen to me drone on about it. So I'm going to give you a quick summary of what's going on with this thing in CP-7. First of all, this is all about what happens. In most cases, this would be a situation where a broker is moving from brokerage firm A to brokerage firm B. And the starting point for this entire discussion is the listing agreements, the exclusive right to buy, exclusive right to sell, landlord and tenant rights, any of those agreements, those are owned by the brokerage firm. The brokerage firm is not necessarily the one who signs it. You're the one who signs it, typically through a designation on the signature page that allows you to sign it on behalf of the brokerage firm, but the actual party to the agreement is the consumer, the buyer, the seller, and the brokerage firm. It's not you, the individual broker. And that's a common misunderstanding, frankly, in our industry, and I sort of understand why. Reason number one is you're the person signing the agreement, and reason number two is because it's your client, it's your family member, your friend, your repeat business, your referral business, whatever it is, it's your relationship. But not legally. Legally or contractually, the relationship belongs to the brokerage firm. So when you're moving to another brokerage firm, it's important to understand that the decision about what happens with that relationship is 100% entirely in the discretion of the brokerage firm, not the individual broker, right? And so that misunderstanding comes up a lot as brokers are deciding to move to a different brokerage firm, and we're seeing more of that. I think as the market kind of thins out a little bit, people kind of go, well, how am I going to shake up my business, or what other opportunities are there out there for me? But this is going to be something that's dictated by the brokerage firm, and it's typically going to be something that's addressed in the office policy manual or maybe the independent contractor agreement, but it is up to the brokerage firm. So first thing to do if you're moving is understand what is the policy for the brokerage firm. What do they do as it relates to a broker moving? Do they maintain or keep the active exclusive right agreements and designate them to another broker, or do they allow you to take them with you? And so we're going to talk about kind of what needs to happen in that situation. First of all, when we're talking about just the listing agreement, in other words, you've got a brokerage relationship with a buyer or seller, an exclusive right to buy or sell, but you don't have a contract in place on that yet. You're just still working to market the property, sell the property, or you're working with a buyer and the buyer is still trying to find a place to make an offer on and go under contract on. That would be what we're talking about in this first slide. And so the broker's moving, does the listing agreement move? Well, the answer is up to the listing brokerage firm, and the answer is maybe, right? If the answer is no, it's not going to be assigned. In other words, the brokerage firm's policy is we keep our listings. Then they need to do, the brokerage firm, the old brokerage firm needs to do an amend extend to the brokerage agreement and redesignate another broker in that old brokerage firm to pick up and carry forward the relationship with that client, the buyer or seller. And that's an amend extend, so it's going to need to be signed by the brokerage firm and the new broker who's going to be the designated broker, as well as the consumer, the buyer or seller, acknowledging that now they're working with, this other broker. All right. Some brokerage firms will say, hey, you can take the agreement with you, and we'll go ahead and assign that. Now, that would be my policy, and my policy would be that way because there'd be a trade-off, and I'll get to that in just a second. But if the policy of the brokerage firm is when you've got an active listing agreement with a buyer or seller, and you leave the brokerage firm, you can go ahead and take that brokerage relationship with you. All right. There's two ways that could occur. Either way number one is that the old brokerage firm would terminate effective immediately the brokerage relationship with the client. And then the client would move with the broker to the new brokerage firm and enter into a brand new brokerage relationship with the new brokerage firm. That would be one way to do it. The other possibility is you could do an assignment of that brokerage relationship. And that could be done either through a brokerage firm assignment agreement, a form that maybe their brokerage firm attorney has prepared or law firm has prepared to assign listing agreements to another brokerage firm. If you don't have one of those, you could use the agreement to amend, extend the brokerage relationship or brokerage agreement form, the commission-approved form, but you got to have three signers on that. It's going to be the old brokerage firm who's the assignor, the new brokerage firm who's the assignee, and then the consumer has to sign. And the form's not exactly set up for that, but to the extent that you can manipulate that form to make sure that you're getting all three signatures and acknowledgments about the movement of the brokerage relationship, that form would work just fine. And then the brokerage relationship is now moved to the new brokerage firm, and the old broker, the original broker, is still the representative for that party. Now, I will say this, in terms of liability, and the commission position statement points this out as well, if the old brokerage firm is assigning that agreement, they have transaction file responsibility and liability from everything from the inception of the transaction up to the point of assignment, all right? And then at the assignment, their transaction file and other liability goes away, and that moves now to the new brokerage firm. The new brokerage firm, however, when they accept an assignment of a brokerage relationship from an old brokerage firm, they have transaction file and other liability from the inception of the agreement, even though that they hadn't received that assignment yet, but from the inception of the transaction all the way through closing. So the entire transaction. And that's one of the reasons I like, if I'm the old brokerage firm, I can say, hey, I'm going to shrug this all off onto the new brokerage firm, and I'm just going to quantify or cap my exposure on this transaction at the point of assignment. Now, in order to do that, my brokerage firm, if that were my policy would also be that in exchange for me assigning that listing contract to the new brokerage firm, the new brokerage firm is going to enter into a referral agreement back to my old brokerage firm for essentially what I would have earned or made if you had just done the transaction here in my office to begin with, right? So you're not really, as the old brokerage firm, giving anything up. You're just essentially shifting the transaction responsibility, liability, and everything to the new brokerage firm, but you're going to, at the end of the day, through a referral agreement now from the new brokerage firm, receive what you would have made and be made whole. The other situation that kind of gets a little bit wonky is same answers, but just want to clarify the distinction, is sometimes as a broker, you're moving brokerage firms, and you don't just have listing agreements. Your clients, the client that you have, the seller or buyer, they actually have a pending active contract with another seller or buyer to purchase a property. And in that situation, the CP-7 points out a couple of things. Number one is the commission has already been earned. The way our listing agreements read is the commission is earned when the contract is formed between the buyer and the seller in most cases, right? It's collected or paid at closing. So in a situation where I'm a brokerage firm and a broker is leaving my brokerage firm and they already have the clients that are under contract, in that situation, my brokerage firm has already earned the commission. And so in many cases, the brokerage firm says, well, no, we're not going to allow you to take that. We're going to redesignate another broker in our brokerage office to wrap up this transaction, all right? And CP-7 points out that if that occurs, then the old broker still has an ability with the consent of the old brokerage firm to communicate and to engage to some degree with that buyer or seller. Because in a lot of cases, the buyer or seller is like, wait a second. I don't want to just lose my broker and be redesignated to a new broker to wrap this transaction up. I trust my broker. I like my broker. In that situation, and with the consent of the old brokerage firm, the broker who has moved could still communicate and engage on some level with that consumer, but they can't perform brokerage functions. They shouldn't be signing settlement statements. They shouldn't be drafting contract amend extends or inspection resolution items or anything like that. That all needs to be done by the broker of record who is at the old brokerage firm. So being present at closing for emotional or personal support or just comfort for that consumer, that's okay if the old brokerage firm consents to that. But performing brokerage functions, that's a no-no, because you can only perform brokerage functions where you're currently and actively licensed. And now that broker has moved on, so they're at a new firm. The other possibility would be to go ahead and assign that brokerage relationship still. You could still assign it to a new brokerage firm, even though it's under contract. That works, and the same process would occur in that situation as the situation where it was just a listing agreement. But the difference being is that the old broker, because they are now a broker of record, they will remain a broker of record at the new brokerage firm. They can attend closing, sign settlement statements. They can do all of the brokerage functions just as they were at their old brokerage firm. And then it gets down into sort of the payment of commissions. And so remember, those commissions were already earned at the old brokerage firm. So you could assign the collection of those payment of commissions to the new brokerage firm, and then the old brokerage firm, much in the other slide that we talked about, could receive a referral fee back to the old brokerage firm in the amount that they had already earned. Alternatively, if the old brokerage firm retains the transaction and designates another broker, they could still pay a commission. They don't have to pay a referral fee. They could still pay a commission directly to their old broker, because, again, that old broker earned the commission at the old brokerage firm. So the old brokerage firm wouldn't have to pay a referral fee to the new brokerage firm, and then the new brokerage firm pays the broker. Because the commission was earned, because in this situation it was under contract, they could pay a commission directly to the broker who left, their old broker, even though they're at a new brokerage firm. So anyhow, that's the summary of CP-7 and some of the information that's in there. It is a great commission position statement, and I think it now clearly articulates some important changes and issues that I deal with all the time on the Car Legal Hotline. A lot of questions, because there's a lot of brokers that are moving and a lot of misunderstanding. So if you have questions about it, you can always call the hotline. We're happy to talk to you there. But for future reference, Commission Position Statement 7 now addresses your questions in their entirety. I promise you, I will be much more regular throughout the spring and summer in generating legal bites so that we can get through this godforsaken Commission Position Statement series. It's eternal, I feel like, and I'm not moving quickly enough. Anyhow, look forward to seeing you guys throughout the spring and summer, hopefully in some of your local associations. I'll be doing my 10 Things classes all over the state between now and fall. So if you see one of my 10 Things classes in your local area, make sure you sign up. Come say hello, and love to see you there as well. Take care, guys, and we'll see you on the next edition of Legal Bites.